Hi, I'm James Minnick of Minnick Law, and today we're going to talk a little bit about refusals and refusal hearings related to a refusal of a chemical test. Typically, this is in relation to an implied consent offense. An implied consent offense in North Carolina could include a driving while impaired charge. It could include driving after consuming any level of alcohol while being less than the age of 21. There are a number of different implied consent offenses, the most common of which is driving while impaired. In North Carolina, a person that is charged with an implied consent offense can be asked to submit to a chemical analysis of their blood or of their breath. At the time that they're requested to submit to that chemical analysis, they are generally read a rights form that gives them certain rights related to that request. When a refusal occurs at the JO or wherever the breath test is being submitted, when a refusal occurs, the person is notified prior to their refusal that their license will be suspended, or at least is required to be by the law enforcement officer notified that their license would potentially be suspended related to the refusal. In North Carolina, if a person refuses a chemical test and is revoked by the DMV related to that refusal, the license suspension in North Carolina is for a 1-year period. A person who is revoked for a refusal would have potentially 2 revocations that would apply. One would be immediately upon the refusal being entered by the officer. That would then be taken typically in front of a magistrate who would issue a 30-day civil revocation of the person's driver's license. The DMV would then also notify the driver by mail of a refusal revocation, which is the 1-year revocation. Once the driver receives notice from the DMV related to that refusal revocation, the letter itself will describe how the driver can then request a refusal hearing. Once that appeal is timely submitted to the DMV will allow the license to remain active pending the appeal. So it's not revoked on the scheduled date that was in the letter. Pending the appeal in front of a DMV hearing officer, the license will remain active and valid, and so it is in full force and effect until there's been a hearing in front of a DMV hearing officer. At the hearing officer really has very limited grounds to consider as far as the issues that can be presented by the person requesting the hearing. One of those issues that can be presented is that the officer that charged the implied consent offense did not have reasonable grounds to believe that an implied consent offense had been committed. The second thing that a hearing officer can look into is whether the person was properly advised of their rights before being requested by the law enforcement officer to submit to the chemical analysis. The final thing that the hearing officer is looking for is, was there an actual willful refusal? For a person with kind of documented medical conditions related to maybe their lungs or other medical problems that maybe would not allow them to submit a sufficient sample of breath into the machine, an officer might find that somebody has refused a chemical test despite multiple attempts to try to give a sample at the jail. The hearing officer that is involved is kind of acting as the judge, so to speak, on these DMV refusals. They can ask questions during the proceedings of both the officer that is involved as well as any other witnesses that are presented, but they are the ones ultimately making the determination regarding whether somebody has refused a chemical test. If the hearing officer determines that there was no willful refusal based on one of those 3 conditions that we just talked about, then they'll send a letter following the hearing that says that your license is not scheduled to be suspended, that the driver's license is not scheduled to be suspended related to a willful refusal. If the hearing officer says that there was a willful refusal, then they will also send a letter on that end and say this is when your license will be suspended for willful refusal. Again, there will be a 1-year revocation typically for a willful refusal, and there will be a scheduled suspension date.